Okay, welcome everybody to the December edition of the Hague Program Seminar, our book seminar series. Uh, as you know, or you perhaps you have joined the last few seminars, my name is Julia Carver. I'm an assistant professor at the University of Leiden, and I'm really excited to welcome Professor Kubo Mačák today, who will be discussing his new book, The Handbook on Developing a National Position on International Law and Cyber Activities, a Practical Guide for States, which is co-authored with Talita Diaz and Ágnes Kasper. And Professor Mačák is a professor of international law at the Law School and of the University of Exeter and a member of the Exeter Center for International Law. He was appointed as a lecturer in 2013 and then transitioned to a senior lecturer towards his professorship in 2023. And he's also led the mooting program at Exeter Law School from 2013 to 2016. And I will also say that he was formerly a fellow of the Hague program. So we're really excited to have him back, albeit virtually, and hopefully to see you in person as well in the future. But so usually how this works, just to set the housekeeping rules, is that we will ask either for you to put your question in the chat for Professor Mačák or to raise your hands. And I understand that Professor Mačák is also flexible if you have a question throughout his presentation to either put in the chat or raise your hand at that point for an interactive session. But otherwise, you're very welcome to keep your questions towards the Q&A, which will occur at the end of his presentation as well. But without further ado, I'd love to hand it over now to Professor Mačák.
Oh, thank you, Julia. And yeah, it's very nice to be here. As you say, we just before starting with Julia, we had a little bit of a chat. I was trying to remember when I was at the Hague program as a fellow, and I think it's 6 or 7 years ago. So yeah, it's indeed very nice to be back, at least in this virtual format. I see a number of familiar names on the list. I don't see anyone's faces yet, so feel free if you like to turn on your cameras. We have a very small group. There's 10 of us at the moment, including myself. So I think we can do this fairly informally. I do have some slides. Hi, Isabella. Nice to see you. Yeah, so I think what we could do is maybe I can talk you guys, and Peter, nice to see you as well. Yeah, I can talk you a little bit through the project, use some of the slides, but I probably won't use all of them because it's a longer presentation that we use for slightly different formats. And because here we are in a small group, maybe it's more interesting also for everyone in the room to have a bit of a chat, see what questions you might have about the handbook and maybe future work that will arise from it. So let's do it in this way. And as Julia says, if folks have questions on the way, I very much welcome it. I don't mind at all. Feel free to jump in or raise your hand. If you put questions in chat, we agreed with Julia that she will relay them to me because I don't think I will see them on my screen. So yeah, so maybe let's get started. Perhaps I can already show you the title slide so that you can also see what the handbook looks like. So can you see the slides now, Julia? Can I have a thumbs up?
Yeah.
Yeah, okay,
yeah,
perfect.
Thanks.
Yeah, so that's what the book looks like. I think what I can say kind of at the very start is that it draws a couple of streams of my work together. One of them was actually already when I was at the Hague program back 2018-19, I think as it was. A part of my work was on looking at how non-state driven initiatives are contributing to the development of international law as it development and clarification of international law as it applies to cyber activities. And so back then in my scholarship, but also others, we were calling on states to be more expressive about their views on how international law applies in the cyber context, because the discussion was dominated by non-state driven initiatives. Probably everyone in this room is familiar with the Tallinn Manual project, but there were also other initiatives at the time. Microsoft was a prominent member of the industry working on such initiatives. There was a lot of scholarship, a lot of it with quite some granularity, but very little discussion coming from states themselves. And so since then, the landscape has changed quite a lot. So, obviously we have Isabella, Peter, and Jack with just among those of you who are there with pictures. And Julia shared with me that she's from Canada. So all of these countries, Canada, Austria, the Netherlands and the UK have issued their national positions, some of them since the time that we talk about. The UK was one of the forerunners, so their position was already out in 2018. And then we have a project that I'm going to talk about in a moment as well, which is a sister project to the handbook called the Cyber Law Toolkit, in which we monitor these positions. And so as of this week, or as of this month, because a few days, weeks ago, we had the most recent position published by Belgium. We have 36, we are counting based on the criteria I'll share with you, 36 states that have issued such positions. So the landscape is very different. But I said that it ties a couple of work streams together. So one was this kind of, let's call on states to do this. And then as it started happening, we started seeing that the positions are coming from a certain part of the world and that other regions tend to be rather underrepresented. And so it's roughly at that time that I switched hats and, I took off my academic hat for a few years and I went to work for the International Committee of the Red Cross as a legal advisor in Geneva. And one of the things that I worked on was the cyber file. And so obviously, as you know, the ICRC has a bilateral confidential dialogue with states around the world. And so a part of my work was to discuss with states what their views are also on cyber, not so much on international law in general, but primarily because of the mandate of the institution on international humanitarian law. And so again, in this context, I started seeing that there was quite a lot of demand to develop the expertise, to develop the understanding of these questions from all parts of the world. And so then when I put my academic hat back on, when I came back in 2023, together with Ágnes, Kasper, and Talita Diaz, as Julia mentioned, who are now the co-authors of this handbook, we started leading this project that resulted in the publication of the handbook on developing a national position. So the overall aim is to help kind of even the ground. So to help those states that might not have considered doing so, or that might have felt there might be certain barriers to their work in this regard, to get the tools based on the best practices and experiences of other states and sort of join the conversation. So I think that's kind of the starting point. So with that, just a couple of things to maybe start zooming in on the debate. Those of you who are following questions of how international law applies in the cyber context, you will not be surprised that we start from a baseline, which is that there is now an agreement that international law is applicable to state uses of information and communication technologies, to cyber activities. There are different names, but the idea is the starting point is there. We are no longer discussing whether international law applies. And so that's reflected in this report that's on the screen. And that's the 2013 report of the group of governmental experts, so a UN mandated group that most people on the call will probably know, but happy to then perhaps introduce these UN processes later on if there is more interest in the Q&A. But the baseline is we know that international law is applicable. The question is, how does it apply? And so the main vehicle of how states articulate this view on how international law applies to cyber activities has been through these national positions. So at the first approach, if you're thinking, what are these national positions? Well, they are public written statements that states issue that articulate these views on the topic. I said that we are monitoring 36 of them. So if you have a very eagle eye, you will see that my slide, I didn't get to update, because actually I did update the slide, but it's the Cyber Law Toolkit where this screenshot is taken from that's not yet updated because the Belgian national position was issued very recently, and so we don't yet have it in the toolkit. But here you can see which states we monitor as those with published national positions. You also see that some of them have issued several. So we can then talk about that also, how states revise the existing positions. And then what you will see at the top of the page is that there are also common positions. So 2 international organizations, the African Union was the first, and then the European Union very soon after that, have issued common positions on these questions, which should reflect the considered view of all the member states on these topics. So then I talked about the Cyber Law Toolkit. Again, many people will know this resource. It's a sort of a sister project to the Handbook. It predates it. It is led by a consortium of 6 institutions, where my university is one of the 6. And basically, it's a platform that contains a lot of resources on international law and cyber operations. What we started with was a list of scenarios. So the little pictures that you can see, those are the scenarios that the toolkit started with. But then as there were more and more of the national positions, one of our colleagues had the idea of that it would be useful, because this has always been supposed to be a one-stop shop for folks working on these questions. It would be useful to complement the toolkit with a database of national positions and then later common positions. And so I think now it's probably 50-50. A lot of people still use the scenarios as a teaching resource for exercises, but the national positions have become a very, very frequently consulted part of the toolkit. If you haven't yet played with it, please don't start doing it right now, although you can open it in a separate window. But yeah, I encourage you to have a look. You might come up with a question, what does state X say about sovereignty? So you just open the page on sovereignty and you will find it there. And you can also organize it by states and so on. So it's a resource that I really enjoy developing, and it became a sort of a predecessor for the handbook in that sense. National positions, I said that there are 36 states with such positions. So if you put them, if you make a chart like this, you see that there are still a lot of states who haven't done so. I am 100% certain, I don't say that often, but I'm 100% certain that we're not going to stay at number 36. I don't know how many there will be in the future, but there are definitely several in the works. So we will see more of these national positions. But one of the challenges is that if international law is meant to be a global framework governing behavior of states and other actors on the international plane, then the conversation about it should also be global. And so in the cyber context, you see that some parts of the world are much more represented than others. So the WEOG is the Western European and Other Group. These are the titles of this group in the UN parlance. And GRULAC is the group of Latin American countries. Yeah, so those are the abbreviations. And you see that it's the Western European group that's the most heavily represented. So there is a need to even this playing field, and so that's what the handbook project started with. And we saw that from discussions that we had with states that it's not easy to develop such a position, and I think at least Isabella from colleagues on the call has been involved in such a process, so you can then confirm or deny that it's not an easy process, because there is quite a lot to do, a lot of views to consult and to consider before such a document can be published. And so that's why they are very carefully crafted by states who have been engaged in this process. So with this, we get to the project itself. So our aim from the start was not to tell states what to do. It's not, you have to do this. It's not a manual in that sense. It's more like, sometimes I explain it as a cross between a Pinterest board, where you can get lots of ideas of things that have worked for others, and an IKEA flat peg assembly, a set of guidelines. So once you know which ideas you have picked and what you want to create, then you look at how you might go about it. But the handbook doesn't tell you that you must do it, Actually, I'll talk about it a bit more unless someone stops me already with a question. One of the key chapters that we have is about motivation. So why should states do that? And that chapter also acknowledges that some states might decide not to do that. And that's a perfectly legitimate and valid decision. But the handbook is there to give as much information to states that might be interested in this. So the partners of the project are, apart from my university, the NATO Center of Excellence on Cyber, so the full name, Cooperative Cyber Defense Center of Excellence, which is based in Tallinn in Estonia, and then two states, the Ministry of Foreign Affairs of Japan and the Ministry of Foreign Affairs of Estonia, both states for whom developing the dialogue on international law in the cyber context is a key foreign policy priority. So it was great that we could have them on board and support the project. I already mentioned the authors, and then now we are kind of in a dissemination phase, which is why I was very happy to get this invitation to talk about the handbook. So we have already published the product. We had 2 launches. One was at CyCon, which is a big international conference in Tallinn in Estonia. And then we had another one at the UN when another of the UN-based processes, so I mentioned the GGE, the Group of Governmental Experts, the other process is called the Open-Ended Working Group. So when that was finishing its work in July this year, we had another state-facing launch of the handbook there. So if you don't yet have a copy, you can now just scan the QR code that you see on screen in front of you, and it will take you to our webpage where you can access the handbook. It's free, as I say, it's available free of charge digitally. And because we are a very small group here, I'm going to say that if colleagues would like to receive a printed copy, feel free to get in touch with me after the call. We have a few left, so we might be able to send you one if you prefer to work with a printed copy. So that's what the handbook is. Then we have lots of comments from our roundtable participants on how this is important. I will maybe let you just skim through it. I will not read them to you, but what I can tell you at this stage is that we organized 3 such roundtables for states, and we consulted a total of 46 states. So we held these roundtables on a regional basis. And the idea was, as I said in the beginning, in some parts of the world, the dialogue, the conversation is fairly advanced. So we felt that there's not that much need to bring discussion there. But we held a roundtable for Latin American countries. We held a roundtable in Addis Ababa for African countries, and in Singapore for countries from the Asia Pacific. Yeah, so those were the 3 regional roundtables. And then a lot of the participants came either from countries that already had a national position or those that didn't, but what united them was at least an interest in developing and clarifying international law in this way. So then you might be wondering, what does the handbook consist of? And so this is what you would find in the table of contents. So those are the main chapters, introduction, then 4 sort of substantive chapters on motivation, process, substance, and presentation, and then a conclusion, which is more forward-looking, and then just some formal parts like the bibliography and annexes. So we have, I said that I would talk for about half an hour, so I have about 10 more minutes. So I see that there are no questions at this moment yet. So maybe what I can do in the remaining time is just to say a few words about each of these chapters. That will take me about 5 to 10 minutes, and then we can open for questions and have a discussion. So from the introduction, and I have lots of slides, so I will be skipping some, but if you see something that you're interested in, then just please either stop me or we can come back to it during the Q&A. So for the introduction, what I would flag, and this is a question we get asked quite a lot, including from states that have come to our discussions, and that's what is actually a national position? And it turns out even that's a non-trivial problem because states express their views in a number of different formats. So for example, I mentioned the ICRC. Now, after my departure from my formal role at the ICRC, they started a global initiative on IHL. And as part of that global initiative, there is a work stream on information and communications technologies through which states come and they talk about various aspects of how IHL applies in the cyber context. So they issue statements, but these are not national positions in our view, because they are too focused. They respond to specific questions that the ICRC poses. And even though some of them are published later, they do not comprehensively, or at least more broadly cover, they do not cover the whole area of international law. So, but reasonable people may disagree. What we finally came down to as the four main criteria for something to be included as a national position, both in the handbook and it's also the approach of the cyber law toolkit, is that the position has to be issued publicly. It has to be issued by a state organ. So most typically, this is the Ministry of Foreign Affairs, but not always. And then available in a written format in a public repository. So that means it's not just a statement somewhere that is not captured and available later on, but you can access it in a public repository, typically the website of the government. But many of them, like the one that I mentioned, the most recent one, the national position of Belgium, to my knowledge, it's not yet on Belgium's website, any of their governmental websites, but it is already on the OEWG website, which is this other UN process that I mentioned earlier. And then the fourth one is published with the aim of expressing specific legal views on the application of international law in the cyber context. So if it was very partial and just focused on one specific question, like those statements in the Global IHL initiative, we probably wouldn't consider them as qualifying as a national position. And so then if you take this approach, then there are 36 states with such positions. If you define it more narrowly or more broadly, the number can differ. And yeah, ultimately, I don't think it matters that much. It's just you have to be clear about what you mean for the purposes of the project that you have. And I think this was also useful for us to have these discussions with the states. So that's what I would highlight from chapter 1. I'm going to skip to chapter 2. So why? So this is the chapter about the why. Yeah, why would states develop a national position? And again, what the handbook says is basically what states told us. It's not our views why they should or shouldn't do so, but it's what we heard as the drivers that they had. And so they flagged external drivers, like a little bit of peer pressure from other states. This was very interesting to me, hearing that states that are part of regional groupings, I have to be careful because all of this was, of course, under Chatham House rule. So they would sometimes say, oh, everybody else in this particular grouping has already issued their position or is working on one. So that's a bit of a motivation for us to work on one as well. And then we heard also of internal policy considerations and drivers, which was sometimes there is a demand from within the state saying we should have this because we need to know what we are allowed to do and what we are not allowed to do. Then states also highlighted how these national positions serve different functions. So like communication of the state's views on the international plane, transformative function, which is what we called to mean that states are also trying to craft or to shape the development of the law in this area, so to transform the framework. And then also what kept coming up was the preventative function. So also to deter certain actions by their adversaries by communicating very clearly, these are our red lines. So that's maybe what to highlight about the chapter on motivations. Happy to go in more depth on specific aims that we have, constraining factors and so on. Then on the third chapter, which is about the process. So here we heard mainly that there are, I think the main takeaway about the process was that no one size fits all. This kept coming up. Every state is different. And, there are some states that, for example, said it's very important for us to consult the indigenous community in our state, because that's just how it works. And we wouldn't be able to adopt anything that would be representative of our state's position without doing these consultations. There were other states that said for us, it's important to consult various stakeholders, the industry, even academia. And there were others who said, for us, it's more of a closed cycle. When we have our agencies, we know which ones have a mandate that reflects these questions, and those are the ones that should be consulted, but we will not open it more broadly. So yeah, ultimately it depends on the state, but what I think all of the processes share is that they are not just about the law. And that was another interesting takeaway from some states. They said, oh, we thought that it would be just us lawyers writing this. And then we shared it with our operational colleagues and they said, no, this is not the way it works and we cannot. And then they had to go back to the drawing board. And and rewrite. So it's an integration, as I say on the slide, of policy, of legal and operational considerations. So that's something that all of these processes share. And then I put here something that is one of my favorite parts. It's not my most favorite part. I will come to that of the handbook, but one of my favorite parts is the checklist that we have in Annex A. And so that's kind of all of the, not all, but many of the steps that the state might want to consider when it comes to the process of developing such a position. And so when you go on our website, we made this available separately. So you don't have to go to the whole handbook. You can just download this 2-page checklist.
Kubo,
So I'm going to...
may I
Yeah,
jump in
please.
quickly? I
Yeah,
just
absolutely.
was hoping to
Let's go
read
back
a
here.
comment in the chat. And I think it
Mhm.
relates to the process to some extent. So Marilyn de Court, forgive me if my pronunciation is wrong, commented that it is curious how the national position of the Kingdom of the Netherlands is stated on the website of CCDCOE, but it only talks about the Netherlands as, quote, "This is the position of the Netherlands on international law applicable to cyber operations." But they go on to say, and not the entire kingdom, but also consists, of course, of the overseas territories like Aruba, Curacao, and Sint Maarten, as well as the special municipalities Bonaire, Saba, and Saint Eustatius. And the question was asking or reflecting on how the islands can get included in the process of developing, or if they were included in the process maybe of developing the national position of the Netherlands.
Okay, so I cannot speak for the process that the Netherlands engaged in. That's not a question. That's not the question that I can answer, or I'm in a position to answer. In the handbook, we list this position as simply the national position of the Netherlands, and in the handbook, so there is Annex B, yeah, which is, so you see Annex A is the checklist. Annex B is the list of positions that we consulted, and here we based ourselves on the short form of country names that is used by the United Nations. And I think because the toolkit is a slightly older resource and it didn't go through the same process of review as the handbook did, it might be that we are using the country name that might not be 100% correct. So thank you for raising this. I'm not sure off the top of my head if it's correct. So it might be that we need to also use the short form, just the Netherlands. But yeah, I will look into it because I mean I am one of the authors of the handbook, but I'm also the general editor of the toolkit, so it's my responsibility to get it right. So it is. I see now in the chat. It is curious because Netherlands is not a state on its own. So yeah, I will need to get advice on this basically. So maybe thank you for raising this. And there is my email probably in the meeting invite, and it will be also on the. You know what? I'll just type it in here. So if you would like to maybe look into it and send me an email, and we can then discuss it bilaterally to see how we can fix this in the toolkit so that we use the correct country name. Yeah, thank you. Okay, so that then takes us. So I'm closing the chat again, and Julia, then tell me if anything else comes up. So that's a process. Then on substance, again, let me just flag it. You know what? Maybe let me show you what we included. So the chapter on substance is the biggest chapter in the book. It contains 12 subsections. And so we based ourselves on topics that are these evergreens, that keep coming up in the national positions. And then those that states that came to our consultations said, actually, we would like to see more of these topics. So in the section that we called foundational rules and principles, we included 6 of them. And so it's good that we have Jack, who is an expert on sovereignty, so he can then tell us everything that we got wrong in the handbook on that topic. But so sovereignty, non-intervention, and the use of force are often referred to as the big 3, that they are typically also covered in that order in national positions. And then we also included here due diligence and peaceful settlement of disputes, and self-determination was one of the newer topics in this area that came up in the discussions. Then we had 3 specialized regimes. And so again, IHL is a common staple. It appears in many of the positions. IHRL, human rights law, a little bit less so, but it's also quite common. And then international criminal law, Isabella, I used to say Austria is the only one, but it's no longer the case because Belgium has a short section on ICL. So that's much more underrepresented in the existing positions. But we felt it's quite an important one. And those who are following this area know that the ICC, the International Criminal Court, its Office of the Prosecutor has just very recently issued a new cyber policy, which contains a very detailed analysis of how the Rome Statute applies in the cyber context. And I would expect that that's going to influence a lot of thinking by scholars, but also by states on these topics. So those are the specialized regimes that we included. And then we put state responsibility separately. Again, it was a structural choice. We had a lot of discussion where it would fit the best, but ultimately we just decided to make it as practical as possible. For some of the states, they cover it in this order, but most of them, if they talk about state responsibility, they talk about primarily attribution. And then two of the circumstances precluding wrongfulness, mainly countermeasures, but there is also some demand and thinking about the plea of necessity. So we included those as well. So those are the 12 sort of sub-chapters under substance. You could definitely include more. The Tallinn manual, for example, is richer. It contains more topics. International law is immensely richer, but ultimately we had to make some choices so as not to turn this into a textbook, but to keep it practical for the purposes that the book has. So that's the sort of second last substantive chapter. And then our fifth chapter, maybe here, let me stop on this slide, is about presentation. So once you know that you want to do a national position, that's motivation. Once you know how you will go about it in your state, that's the process, and what you will put in it, substance, your job is not yet done because you have to still decide how you're going to present it. And so here we covered a couple of things, but before I go to them, I see, Isabella, that your hand is up. Do you want to come in on this?
Yeah, I had a question about the slide before, actually, if you don't mind.
This one.
Thanks. Yeah. Also good to see you, of course. I didn't say hello yet, but yeah.
Yeah, nice to see you as well.
Yeah. This is super amazing, and thanks so much for doing this. I had a question on the attribution point where you it says threshold. I'm curious if that relates now to do you mean the control threshold or evidentiary thresholds, or what exactly did you mean with threshold? And potentially that's also in the handbook, so I might just read that one, but I was just curious if you could elaborate. Thank you.
Yeah, so yeah, you're right. There are a couple of thresholds. Probably this slide should be a little bit clearer, but we have under attribution of conduct of non-state actors, we discuss where the threshold for that would lie, and we acknowledge this debate that you're very familiar with. So for those colleagues who have not been following it, so for the attribution of conduct of non-state actors in general, the key provision is not the only one, but the key provision that governs this is Article 8 of International Law Commission's Articles on State Responsibility, which contains three standards, so three thresholds, if you will, instructions, directions, and control. And so for instructions, I think we are fairly certain we know what it means. Direction is quite often just ignored. People don't talk about it too much, or they merge it with the criterion of control, which in my scholarship I have caution against, and I argue they are actually disparate standards. But where most of the debate is on this question of control. And so within that standard, where the threshold lies, in the sense, how much control must the state have over the non-state actor in question? And so here there are two standards. One is the standard of effective control, which is the higher, the more demanding standard. And then a lower standard of overall control has emerged in the case law of the International Criminal Tribunal for the former Yugoslavia. So in a slightly specific international criminal law context, but there were authors, now it's not so common, but some time ago, who were arguing, oh, actually, because in the cyber context, it's so difficult to determine whether, you know, who is behind a specific cyber activity, we should lower the threshold to make it more realistic that it can actually be met in specific circumstances, because otherwise all of this will go under the radar, all of the activities of non-state actors. But that argument has not won favor with states. So to my knowledge, there are 4 states that talk about the applicable threshold, and all of them have endorsed the effective control standard in the cyber context. So far we have no, I mean, it's not many states, it's still just 4 out of 36, but we don't have any state that would say, yes, we want to lower the threshold. And it's understandable. States are cautious about saying, yeah, we would be responsible for this type of conduct. So yeah, that's a good question. And it's a very short section, Isabella, the section on attribution, so you can skim through it quickly and also tell us if you disagree. Okay, so
Kubo, could I jump in quickly?
Sure,
That's
please.
all right?
Yeah,
there's a question on the chat that came from I think related to chapter 3 actually, but we had progressed. And the question is, could you please share more insights from the roundtable held in Addis Ababa? And the follow-up question, and although you mentioned it's under Chatham House, but the question is from Ramsha Ashraf, asking, I'm wondering if Somalia was included in consultations, and if yes, then what position they held.
Okay. Yeah, with pleasure. So yeah, I think we can address that here, and then I'll talk a little bit about the presentation, and then wrap up, and we can have a more general Q&A. So a quick answer is that Somalia did not participate in the consultations. We invited all African Union member states, and some of them accepted our invitation and others did not. You can see who those states that were consulted were. We are open about it, and that's in Annex C. So we have already mentioned Annex A with the checklist, B with the common positions we looked at. We have 2 more. So C is the list of participating states, and I had a quick look if I'm not forgetting them. But no, the answer is Somalia was not a part of the consultations. And insights from the roundtable that was held in Addis Ababa. So every roundtable was different. We had a very fruitful and really interesting discussion in Addis Ababa. There was more demand to talk about substance than at other roundtables. So we also adapted our schedule, and normally we had 1 section on substance. So normally our structure was exactly as the handbook is now, 1 section on process, 1 section on motivation, etc. In Addis Ababa, we did 3 sections on substance, and we divided them by these key topics that were discussed more. And a lot of the questions were really discussing, so what if this happened? And, what if there was a data center that would be involved in a cyber operation, but it would be located on another state territory? And so we had to scratch our heads, and, often us as the expert briefers who were there, we said, well, we actually don't know, and it's useful for states to express their views on these questions. Africa is a continent with only 1 national position, and that's from Kenya. So I think there is also strong demand for legal capacity building, in the sense, let's just talk about what international law means in this context. And that's why there was more discussion about substance. And then another topic that kept coming up in the African context was the common African position. And so we had a wonderful advisory board with 8 members for the project. And one of them was Mohamed Helal, who will be known to many people on the call. So he was the special rapporteur of the African Union and his mandate was to work on this common African position. So you could say the pen holder, or definitely one of the pen holders working on the position. And he also came to Addis Ababa to brief one of the sessions. And we kept coming back to some of the topics that were covered in the common African position, and how those could then be developed for states in their individual positions. And when I think about the follow-on work, which we can come to when we do the actual Q&A, what we could do on the basis of the handbook in the future, I think one of these possible follow-on works is to go to the regions that are still less well represented and engage more with states on the basis of, now we have this resource, how can you use it? How can you develop and prepare your national positions on its basis? And that would hopefully involve also Somalia, that the questioner asks about. So, all of the states in the world. And I see there is another question now that I opened the chat. in your experience in conversation with states, were there any that shared why they do not want to develop a national position? Ah, yes, I didn't talk about it. Yeah, thank you. That's a great question. Yes, because I said that no in the beginning that the chapter on motivation also says you might decide not to do it. Yeah, so maybe 2 or 3 main reasons. One is the lack of capacity. So what I have just said, there are states that say, oh, we would love to do this, but we need to study more, we need to understand more the issues. So come and teach us, discuss with us, help us engage in these discussions, and then maybe. So that's one thing. And this capacity building doesn't only concern questions of how international law applies in this context, but sometimes it's also, it relates to technical questions and to interactions between the two of them. And then another key issue that came up was operational flexibility. So this desire to hold your cards close to, close to yourself. So yes, we have some views, but we don't want to necessarily share them. And then the counter argument that other states would say was, well, but isn't it good to share your red lines at least, so that others know, what would be unacceptable for you. But some states maintain that for the time being, they prefer this operational flexibility. And then I say 2 or 3 because the third one is not really a reason not to do it, but it's a reason why it can take longer. And so that's interagency coordination. And so for some states, this is not so complicated. And other states said, oh, we really need to consult with many parties and it just takes long. One example that I can give, because it was given publicly, so Thailand, when they announced their position, they said publicly at the OEWG that they consulted 20 internal agencies. So it's a lot of work, but it also shows that it's possible. Yeah, but sometimes, and this is again not talking about any state specifically, sometimes what we hear is that the Ministry of Foreign Affairs, so the key stakeholders typically are the Ministry of Foreign Affairs and the Ministry of Defense, can also be the intelligence services. And so typically the dynamic that we would hear about is that the MFA, the Ministry of Foreign Affairs, is very keen. They want to go out and they want to participate in these discussions and they're ready to put something down on paper. And the MOD says, oh, wait a minute, we need to really think about how this would affect our operations and we need to consult more and be a little bit more conservative. And so then this interagency dynamic can be, to answer the question, this possible third reason why it takes a little bit longer for states to develop their position. So I hope that answers the question. Sounds like it does. Okay, so how am I on time? Yeah, well, now I got a little bit derailed. So yeah, so that we keep some general time for discussion, let me just very quickly go over presentation. And we can go into all of this more, and there are pictures and things and examples in the handbook, so feel free to then explore. But it refers to things like format and style. Here, the trajectory is from shorter and from more discursive contributions, even speeches in some time ago, to more formally structured, even footnoted and slightly longer positions. Again, not to single out Austria, but I think it's one of the longer ones, a bit over 20 pages. So the academic in me is very happy to see these longer positions. But I would say in general, or on average, they are about 10 to 12 pages. Then language, here we looked at the way that they use legal terminology to communicate specific points. So for example, if you want to say that the law is not yet there, you can say things like state X is furthering the position that, and so then you're sort of signaling that you would like the customary international law to develop in that direction. And there are other examples. And then also for states for whom English is not their official language, which is the majority of states in the world, there are some considerations on whether you already work in English or you only issue in English, etc. And then we also talk about various channels for dissemination. But yeah, I mean, you can see some of them on the slide, and maybe we can leave it for the Q&A. So then the conclusion, I think this, a lot of the things that are on this slide we already talked about. So I will maybe just the very first point that what we see that the positions help us do is we can map out where states agree and where they disagree, and then also where the possible gaps are. So one question that hasn't yet come up in the Q&A, but very often we hear it, is whether it's a good idea to work on a binding legal instrument. So, you know, that's quite closely linked to this discussion. And then the first layer of answer is that it's really useful to have these national positions, whichever position you take on a binding legal agreement, because in seeing where states disagree, you also know if there are gaps that might in the future be plugged by such an instrument. So we can go to any of these points later on. I think we talked even about the annexes. And so just so that I don't forget, these are the institutions that have contributed. I have mentioned all of them, and we are also grateful to the UK Economic and Social Research Council. So that's a part of the UK research framework that supported us with a grant. And then we had a number of partners that helped us mainly with these regional roundtables, including the African Union, the OAS, Germany, and National University of Singapore, and Tallinn University of Technology that helped us in various ways. So I would like to also acknowledge them in this format. That brings me to the end of my presentation, and we still have 15 minutes for the Q&A, but we already covered some of the questions already. So Julia, maybe the way we can do it, I pass back to you. I'm going to stop sharing, and we can have a chat in the remaining time we have.